Okay, everybody, welcome. My name is Erin Toomey, for those who don't know me. I am a partner in Foley & Lardner's Detroit office, and I specialize in the area of federal government contracts. I think this might be my 17th seminar I've participated in or put on. This presentation is one I've given before, and really the impetus behind it was there's a lot of presentations and discussion out there about enforcement mechanisms the government has, whether it's Civil False Claims Act liability, criminal liability, suspension, debarment. As I always tell folks, you do business commercially, something goes wrong, you get sued. You do business with the government, something goes wrong, someone can go to jail. That's enough for them to hire me, by the way. That's my pitch. You got it. But what we don't always focus as much on is the contractual liability issue. So that's what I'm going to talk about today. It often comes up too because in predominantly commercial companies, there's a lot of mechanisms and restrictions around contracting. You need to use our form. You need to make sure to get this indemnification. You need to limit liability. You need to disclaim warranties. The government's different. And so part of being a government contractor is understanding the nuances where you can and cannot push back with the government and what protections that you do have. So I'm focused today on government prime contracts. Government subcontracts are going to be a hybrid between commercial principles and government principles. But because we only have a half hour today, I'm only focusing on those prime contracts, those contracts directly with the government. The government uses its own forms for your solicitations and contracts. You can't send them your terms and conditions and say, oh, our contract's subject to these. It's just not going to work. It's not going to fly. The only time when the government can accept some of your form agreements is if you have an end user license agreement, a EULA, when you're providing commercial software or commercial terms of service. There are some terms in there that will be knocked out because they're unenforceable against the government and the government can't accept them. But other than that unique situation, the government cannot generally accept your terms and conditions of sale. The government is also unable to agree to open-ended indemnification provisions. It's a violation of the Anti-Deficiency Act for the government to agree to indemnify contractors because there's no appropriations for it, and the government cannot agree to spend money that has not been appropriated to it. The government can agree to a cap on indemnification if it has that budget authority, but it's a rare circumstance in which that exists. So we're going to talk about termination for default, termination for cause clauses, liquidated damages, and warranty. We don't have time today to talk about loss or damage to government property, patent indemnity, some other areas where there might also be some contractual risk. So in terms of terminations for default, it's called a termination for cause in commercial item or commercial product and service contracts now. But the FAR clause for fixed price supplies and services provides that the government can terminate for default if a contractor fails to deliver supplies or perform services within the requisite time frame in the contract, if they fail to make progress so as to endanger performance, or if they fail to comply with any of the provisions of the contract. So there's a bit of a catch-all there. While it doesn't reference a material requirement of the contract, materiality has been read in, so it would have to be a breach of a material requirement of the contract. For a cost reimbursement contract, the basis for default is any default in performing the contract. Again, that also includes a failure to make progress so as to endanger performance of the work. For a commercial product or service contract, it is a basis for the government to terminate for cause if there's a default by the contractor, a failure to comply with any contract terms and conditions, or a failure to provide the government upon request with adequate assurances of future performance. And then similarly with construction contracts, a refusal or failure to prosecute the work with the diligence that is required in order to complete the contract on time as specified in the contract. All of the contracts do contain some excusable delay language. I only cited here the language for commercial product and service contracts, but both fixed price cost reimbursement contracts also include a force majeure type clause that says a contractor is not going to be terminated for default if they are delayed based on a fact that's outside their control and without the fault or negligence, not only of the contractor, but its subcontractors as well. So it's not enough to say, well, government, I was willing to perform, but my stinky subcontractor over here, they're the ones that made me late. That's not going to fly unless they had a force majeure event that caused their delay. You as a prime, you're responsible for the conduct and actions of your subcontractors. But that is one of the excuses, if you are going to be late, to look at what is the language in that excusable delay clause in your contract, and is there a basis to seek an extension of time based on that, and so therefore the government doesn't think that you're late. The government is required to provide contractors with notice, a show cause notice, before they go ahead and just terminate for default or cause the contract. It's not required, though, that the government give notice if you're late. If you're late, you know you're late. Everyone knows you're late. The government doesn't have to give you notice. While there's no show cause notice requirement in a commercial product or service contract, FAR 12.403C1 does say that the contracting officer shall send a cure notice prior to termination of a contract for reasons other than late delivery. So it's not in the clause, but it is in the policy section of the FAR for commercial product and service contracts. In the fixed price termination for default clause, you have 10 days to respond to a cure notice, or longer if the government agrees. So what happens if, despite the fact that you got a show cause notice, you timely respond to it, and the government still says, nope, not good enough, we don't think you're going to perform satisfactorily, or you're not curing your breach, or we don't think you're going to comply with this term or condition, so we're going to terminate your contract. If the government does that, the FAR says that in fixed price contracts, the government could go ahead and re-procure under the terms and in the manner they consider appropriate supplies or services similar to those terminated. And we'll talk about that similar language. Also, the contractor is going to be liable to the government for any excess costs for those supplies or services. Also, if the government terminates for default, the government can require the contractor to deliver manufacturing materials, which includes any completed supplies that the government then goes ahead and pays for, partially completed supplies, or if there's any tools or dies that the government's going to need to have somebody else perform that contract. But the key here is also drawings, information, and contract rights. If the contractor has specifically produced those or required them for the terminated portion of the contract. That gets to be a little dicey there, because that's your intellectual property, right? And in this clause, it says if you're terminated for default, the government could require you to deliver that, and then you negotiate a price for it. Again, it is required that you have to have specifically produced it under the terminated portion of the contract, but it is still something to keep in mind when you're saying, I don't really care if they terminate for default, they can require you to do this. And there's also a catch-all that the rights and remedies of the government are in addition to any other rights and remedies provided under the contract. The commercial product and service clause is a bit broader. It's not as detailed. It just basically says that if you're terminated for cause, the government only has to pay you for completed work that's been accepted prior to the termination. And the contractor is liable to the government for any rights and remedies provided by law. So it's a little bit more of could dig a bit into some of the commercial space. A bit of a saving grace, though, is FAR 52.212-4, which is in every commercial product or service prime contract, does specify that the contractor will not be liable for consequential damages. So there is a consequential damage waiver built into the contract. So going back to that language of the FAR clause in a fixed price contract that's non-commercial product or service, contractor only gets paid for work delivered and accepted prior to the termination. If a contractor has received progress payments or any sort of milestone payments under the contract, but those progress payments have not yet been fully earned, the contractor may have to pay those back to the government. So the government generally can just get back any money for any work not performed. So if you had some sort of contract financing, that's something to keep in mind. Again, the requirement to deliver the manufacturing materials, as I said, it could result in your competitors having access to your intellectual property. So the clause says that the government's required to procure similar goods or services. And then the government can come back and charge to the contractor the difference between what the government was going to pay you for those similar goods or services and what it has to pay the replacement contractor. Typically, that's more than what they were going to pay you. Number one, because they're doing it on an emergency buy basis. So they usually don't have as much time to do a full competitive procurement. The requirement is not that it be identical to what they're going to buy from you. It just needs to be similar in physical and mechanical characteristics as well as functional purpose. So if there are some small differences, it could be that if you say, okay, well, government, you kind of purchased this additional upgrade from them, you weren't going to get that from us. That could maybe be a discount in terms of what they get from you, but it still needs to be similar. If it is not similar, then actually you don't owe the government anything. Sorry, this keeps knocking. So if it's not a similar product or service, you do not end up being liable for reprocurement costs. The government also cannot materially alter the terms and conditions of the contract. If you needed to comply with Davis-Bacon and the new contractor doesn't, well, that wouldn't be fair, right? So you can't materially alter the terms and conditions. So excess reprocurement costs, as I mentioned, it's a difference between the reprocurement price and the original contract price, but the government does have a duty to mitigate its damages, both in terms of who they select and the timeliness of selecting a reprocurement contractor, as well as in establishing that reprocurement price. They can't just go out there and pay 3 times as much because that wouldn't be reasonable. The government has to show that they actually incurred those reprocurement costs. So you actually are not liable to pay the government until after contract performance, and they've actually paid out all of those costs. The other sticking factor is if you have a base year contract with 4 option years and you get terminated for default in the base year, you are still on the hook for the reprocurement damages for the base year and all 4 option years to the extent the government exercises them. So damages could get pretty high in that circumstance. And then if you have a contract that permits liquidated damages, which we'll talk about next, those are in addition to the government's reprocurement costs. So again, it's a situation where the cost could rise. The government also can get actual damages that they haven't been able to, that's different than the reprocurement costs. However, if they've already recovered through a liquidated damage assessment, they can't get those actual costs. So for example, in a construction scenario, let's say you have a replacement contractor, you have to pay them more, but you also have to pay longer for rental space for the displaced people because it's taking 3 months longer than expected. You don't have a liquidated damage clause. The rental cost could be actual damages that the government can come back and request. And then also there's some agencies like Defense Logistics Agency that has a clause that requires the payment of administrative costs of the reprocurement. Usually they'll have a dollar amount. I've seen like $1,550. At this point, that's not probably going to break the bank, but it's something to be looking out for. Cost reimbursement contracts are different, and if they're more beneficial to the contractor, if there is a termination, the contractor will actually get paid for all the costs that incurred prior to the termination. It's not conditioned on acceptance. However, the total fee will be reduced. So that fixed fee or however the fee is computed will be reduced. The contractor, though, will not be liable for reprocurement costs. But any sort of, it's not like it's a termination for convenience. So any sort of termination settlement proposal costs, those are unrecoverable. They're unallowable costs. In addition to the potential liability financially for a termination for default or cause, it also is a bit of a black mark on your record. So in your SAM registration, companies need to indicate whether or not they've had a contract terminated for default or cause in the last 3 years. And this would require you to check yes. Even if it was a smallest contract you had, shortest term, whatever it is, you'd have to say yes for 3 years. And then you'll have to explain it when you're bidding on new contracts. So it becomes part of your responsibility determination. If you do not think you were rightfully terminated for default or cause, you can contest it. There's a few ways that you could appeal it. The first is to go to the Armed Service Board of Contract, the Board of Contract Appeals, not necessarily ASPCA. The Board of Contract Appeals, you have 90 days after you receive the termination notice to do that, or you have a year to go to the Court of Federal Claims. The best bet is to argue that the termination is improper because either you were not in default or your failure to perform was excusable, whether it's based on one of those excusable delays or some other cause beyond your control and without your fault or negligence. Or maybe it was based on government confusion, or you're waiting on the government to do something and the government failed to do what they needed to do. If you demonstrate that the termination for default or cause was improper, the result is it gets converted to a termination for convenience. The benefit there is you're no longer on the hook for reprocurement costs or any other actual costs the government incurred. You're not responsible then for the liquidated damages, and any of that would go away. It would instead, you're left with being able to submit a termination settlement proposal where you get paid for all the costs you incurred prior to the termination. You do not, however, get lost profits. That is not going to be paid. Liquidated damages. The FAR says that the contracting officer should consider the potential impact on pricing, competition, and contract administration before using a liquidated damage clause in a prime contract. And they should only use it when time of delivery or performance is so important that the government's going to incur some costs that it's really difficult for them to ascertain what those costs will actually be if performance is delayed or delinquent. Liquidated damages, however, should not be punitive. So it's important that the amount is reasonable in relation to the issue and it not be for punitive purposes. The amount of the liquidated damages in the contract have to be a reasonable forecast of just compensation for what harm the government may incur. They can also use a maximum amount or a maximum period. So they could say, after 30 days, we'll stop assessing, or there could be a step down where it's within the first 30 days, X amount. After that, it's less. They could also, their government's obligated to take steps to mitigate the incurrence of liquidated damages. So if there's something, like I said, let's say construction project's late, you're leasing a building, but actually half the building is done and those folks can move out of the leased building and into the newly constructed part, and you can reduce your leased amount, they'd have an obligation to do that. There also is a liquidated damage clause that applies to supplies, services, or research and development. So we see it mostly in the construction context, but read solicitations carefully, okay? It could be included in a contract for supplies. And again, these liquidated damages are in excess of a reprocurement cost under a termination for default or cause. They're not instead of. And these costs could accrue until the work is completed. So if you are terminated and then the government takes 3 months to reprocure and that contractor takes a year to perform, you could be on the hook for liquidated damages for that entire time if there is no maximum in your contract. There are two other circumstances where a contractor could be subject to liquidated damages. One is if you fail to make a good faith effort to comply with your small business subcontracting plan. That includes a willful or intentional failure to perform in accordance with the plan. The amount that, and I will tell you, I've yet to see this in practice that the government does this. I think that sometimes they'll audit, they'll find that you maybe are not diligently following your plan, you're really coming short on meeting your goals. I mean, this takes some egregious conduct in order for the government to assess these liquidated damages. But it is important that you document all of your efforts to comply with your plan, that it's not something you just put in the shelf and forget until next year, but that you're going to conferences, that you have supplier lists, that you are actually documenting your procurements and whether or not you're choosing small businesses. So documentation is critical here to rebut an allegation of bad faith. Another clause that assesses liquidated damages could be the Contract Work Hours and Safety Standards Act. This only applies when a contractor has laborers or mechanics and it requires them to pay time and a half for hours worked over 40 hours in a work week. And there's specified liquidated damages if a company fails to do so. So next I'm going to move to warranties. This might be surprising, but the use of warranties under the FAR is not mandatory. Except for commercial product or commercial service contracts, an express warranty negates any implied warranties. So in the commercial world, we have the implied warranty of marketability, the implied warranty of fitness for a particular purpose. And contractors hate those. They disclaim them all their time in their standard terms and conditions. If anyone closely read a commercial product or service prime contract, clause 52.212-4, there is a clause that says warranty, paragraph O. And that warranty is the implied warranty of marketability and fitness for a particular purpose, but they're not implied, they're express. And so those are the warranties you're giving to the government when you are selling a commercial product or service to the government. Number one, it also doesn't make sense in a service contract because it's actually a warranty for the sale of goods. It doesn't even apply to services. But the good news is that paragraph O can be negotiated with the government, and it can be tailored. That's one of the few clauses in the FAR that can be tailored. So that's something to keep in mind when you're submitting your proposal, and you have a risk mitigation team at your company that says, we never accept these implied warranties. You'll want to make sure that you're negotiating those with the government as you go along. If the government specifies your design, the government makes a warranty with respect to that design. The contractor is only obligated to correct any defects in material or workmanship. If the contractor specifies the design, however, a contractor's warranty also extends to the usefulness of that design. Warranty clauses also don't limit government's rights of inspection in relation to remedies that they have. So any sort of acceptance by the government is not conclusive if there's any latent defects, fraud, or gross mistakes that amount to fraud. So you can't say, oh, the government didn't notice, they accepted it, woohoo. That might not work. Patent defects are any defect which exists at the time of acceptance and is not a latent defect. A latent defect exists at the time of acceptance but cannot be discovered by a reasonable inspection. So that's the difference. If it's a patent defect, the government is expected to be able to notice it if there's a big dent in the side of the product being delivered. But if it's a latent defect where government wouldn't be able to tell that there's that defect unless they actually try to run it, then that would potentially be a latent defect. If the government alleges fraud, they have to prove that its acceptance was induced by relying on a misrepresentation of fact that's actual or implied, or the concealment of a material fact that has been made by the contractor with knowledge of its falsity, or in reckless or wanton disregard of the facts, with an intent to mislead the government into relying on that misrepresentation. And as a consequence, the government has suffered injury. So that is the government's proof to if they want to revoke acceptance based on allegations of fraud. And then for a gross mistake amounting to fraud, it's the same standards that we just talked about, but there was just no requirement that you had intended to mislead the government. It was just a very big mistake. Let's say you sent the government mistaken test reports, not intentionally, but there was a really gross mistake in there where you said this passed the test, but there is a big decimal error in it such that the product did not pass the test. That might be a gross mistake amounting to fraud. The FAR provides that the warranty shall permit the government to, at a minimum, obtain an equitable adjustment of the contract or direct the contractor to repair or replace the defective item at the contractor's expense. But if repair or replacement is not practical, maybe the products are overseas, or it doesn't provide a sufficient remedy, the government can retain the defective item and reduce the contract price accordingly, or arrange for repair or replacement at the contractor's expense. The duration of a warranty has to be specified based on certain factors, such as the estimated useful life of the item. So for example, for a vehicle, that might be based on how many miles, the nature of the item, including what the storage or shelf life, and trade practice. If you have a breach of warranty, you have to then pay for all costs of furnishing labor and material to, again, fix the issue, fix the defect, and replace it. So those could be the cost of shipment back to your facility of all the products. It also could include the cost of where you have to, what it takes to take the products out of wherever they've been installed. For commercial product and commercial service contracts, I kind of got ahead of myself here, but again, this just goes to the fact that the government's required to take advantage of commercial warranties, including extended warranties where possible. And the government can include in a solicitation an express warranty, but they need to have the parameters for that warranty. Here are the FAR warranty clauses. So if you want to look them up or have a question about any of them, this is where they're listed. The government is not supposed to include warranties in cost reimbursement contracts unless it's authorized in accordance with agency regulations. Under the inspection clauses that apply to cost reimbursement contracts, the contractors do have to replace non-conforming parts, and those replacement costs are allowable, but you are not allowed to get any additional fee or profit based on that additional work to replace them. And again, if the contractor doesn't do that timely, the government can do it themselves or reduce the fixed fee under the contract or terminate for default the contract. Under the cost reimbursement FAR clause, however, if there's fraud, lack of good faith, or willful misconduct on the part of the contractor's managerial personnel, the contractor then needs to correct these at its own expense. Okay, techniques to reduce risk. So now you're all like, oh no, we're going to be liable for all this money. This is expensive. First, subcontract flow downs. The key thing is you want to make sure that your subcontractors are obligated to the same FAR clauses, DFAR clauses, other agency supplemental clauses that you are, same warranty that you have to provide. Maybe it's even longer because it maybe once you get it from the supplier, takes 6 months before it goes to the government. So if you have a 1-year warranty for the government and your subcontractor gives you a 1-year warranty, you're exposed for 6 months. So again, you want to flow down all material terms and conditions to your subcontractors. So if they fail to comply or if they breach, you can flow down the liability to them. If they didn't comply with the specialty metals clause because you never flowed it down to them, and all of a sudden you get a show cause notice as to why you're not complying with that clause, it's on you. You never told them. And now you can't pass on that liability. Limitation of liability for commercial product and service contracts, as I mentioned, there is a consequential damage waiver, so that's great. The other thing that I always tell clients is if you're only in the commercial world, you're also concerned about why isn't there a disclaimer of other types of damages like lost business opportunities or reputational type damages. This is the government. They don't compete with you. They're not in the commercial marketplace. They don't have those types of damages. So a lot of the risks that you have in the commercial environment actually don't apply to the government in that they're not going to have lost profits, for example. There is no FAR clause that prohibits you from including a limitation of liability clause in a contract with the government. Now, that said, the government's pretty reluctant to accept them, but it's not expressly prohibited. I think your best chance at getting it accepted is if you exclude any sort of liability that the government cannot waive. They cannot waive liability under the Civil False Claims Act, criminal liability, suspension, debarment. There's categories that are just beyond their control. They're not going to say, go ahead, engage in fraud, and at most you're going to be responsible to us for the value of the contract. They're not going to do that. However, they might be able to say, okay, we'll cap any sort of breach of contract, warranty, liquidated damages at X amount. So if that's a big concern for you on a certain contract, it might be worth the ask. Another way to mitigate risk is to procure insurance, especially in this day and age for things such as cyber incidents or other areas. Insurance could be a way to defray that risk of liability with the government. In construction contracts, you have performance bonds and payment bonds. Sometimes they're required by the contract. Those are an insurance policy. It's a way to kind of defray your risk. There's also builder's risk insurance that some companies choose to get in the construction context. Also, directors and officers liability, D&O insurance is something to be considered. If you have an issue arise, make sure you're reviewing your policies and talking to your insurance agents to see what may or may not be covered. There is something known as the government contractor defense. It's a common law defense, and it's available when the government approved pretty precise specifications for goods or services. So it has to be that the government told you what they wanted, and here are our specifications. The goods or services conform to those specifications. The contractor warned the government about any dangers in using the goods or services that were known to the contractor but not the government, and the government went ahead and accepted that risk. So basically, it's a bit of the government told us to do this. We told them there were these risks. They told us to go ahead anyways. We built it to their specifications. It's not our fault. So that's known as the government contractor defense. The other thing that can help you is maintain adequate records, especially if there's an issue where you're delayed on a project, maintaining records so you can show a critical path chart of what delay happened consecutively, the causation. If there's any issues where the government's causing delays, the government was supposed to provide you a product or a government furnished property and it was defective, whatever it is, make sure you have adequate documentation, as well as sometimes it's well, I don't think I'm going to get the government to agree to this in an email. Well, then have a call with them and then you send a confirmatory email. As we discussed, government contracting officer has to always be copied, by the way. You said we could do X, Y, Z, and they may not respond. If they respond and disagree, at least they disagree. But those are the types of records that you want to make sure you're maintaining to rebut any allegations of a breach of warranty, termination for default or cause, or assessment of liquidated damages. As I said, there's certain liability that cannot be limited. That's the Civil False Claims Act, criminal penalties, suspension, debarment. However, you can have an effective compliance program, and those will reduce those risks, and Caitlin's going to talk to you about those in just a minute.
Well, good morning, everybody. I'm Frank Murray. I'm a partner in the Foley's Washington, D.C. office, and one of the things that I do in my practice is litigate bid protests, whether that's for a company that's protesting a contract award or an issue with a solicitation, or sometimes the company's won the contract and somebody else has protested, and we intervene on their behalf to try to make sure that we can help the agency defend the award. So I'm going to speak a bit today about bid protest basics. Here's what we're going to try to cover. Some of the basics about bid protests. One of the tools that really can be of big benefit both in filing a protest or perhaps sometimes even in deciding that a protest would not be successful and deciding that you don't have a basis to protest is a debriefing, post-award debriefing if you are in a negotiated procurement, so we'll talk about those. And then I have a series of practical pointers on things that I think are keys to successful protests or mistakes that you can make that will hurt your chances at winning a protest. You know, I call them ways to lose a protest. So we'll kick off right away. You know, what is a big protest and why do you file it? Basically, you think that the agency has committed, you know, if you're looking to file a bid protest as opposed to having one filed against an award to you, you're doing it because you think the agency is committing some kind of error, whether it's in how they frame the solicitation. You can have a pre-award protest where you're challenging some aspect of the solicitation as being improper, or if you win the award, or if they've made an award and they've given it to somebody else and you think you were not properly evaluated or that the award is somehow improper, you're filing a protest of that. You know, oftentimes if you are the incumbent provider and you didn't win the award, then there's actually an extra incentive to file a protest, because if you get the stay of performance, you can stay in place while you're litigating whether you should have won. And oftentimes as an incumbent, you know, you feel pretty confident that you have the experience advantage and other things that you should have won. So there's a good incentive there. And again, one of the benefits at GAO is if you win a bid protest on the merits, GAO will typically recommend that you be reimbursed your attorney's fees. So there's some benefits to filing a protest. And I use this analogy. I don't want to overuse it, but you know, to me, it's kind of like, you know, we're in football season now, and even baseball, I guess, now has the booth replay, sort of the replay review. So it's kind of like you're throwing the challenge flag and asking, you know, the referee on the field, the contracting officer, or the source selection authority has made a decision about how the solicitation should be or who should win the award, and you're actually sort of trying to pause the game and have somebody else, a third party, look at it and say, did they make the right call? And so, you know, you have to be an interested party, though. So, you know, at GAO, if you're sixth in line for award and all you're challenging is the awardee shouldn't have won, but there's 3 or 4 other people ahead of you in line, and if you knock out the awardee, you're not going to win anyway, you're not an interested party. Same thing if it's, you know, if it's a small business set aside and you're a large business and you have to challenge that it's an improper set aside. If the set aside's proper, then you're not going to be able to bid anyway. So you have to have an economic interest that would be affected. And so that's the next in line for award can sometimes be tricky. If you're challenging that you were improperly evaluated, then sometimes that kind of throws your evaluation into flux, that maybe you wouldn't be fifth in line. If you were evaluated properly, you would be next in line. But again, if it's a very clear-cut situation where there's some people ahead of you who would win if your protest arguments were valid, and you wouldn't win, then they won't consider you interested party. So these are sort of the standards for interested party status, that you have to have a reasonable chance of winning the award if your protest succeeds. And if you're a prospective offeror, so that's if you've actually filed an offer. Sometimes, and we'll talk about this in a couple of slides, when you're challenging a solicitation. So I mentioned the small business set aside. You may be a large business and the agency's put out a small business set aside So you're not eligible to compete. So you can't submit an offer. But you don't think that there are 2 or more small businesses that would be able to offer this product or this service. And so you don't think that under the regulations that the agency should be setting this aside for small business. So if you can come in and challenge that as a prospective offeror, that if you're right and the agency's wrong, this should be open to all large businesses, then you would be able to compete. But again, if you're not eligible to compete otherwise, then you have to be challenging something that would make you eligible for you to be interested. There are certain things you can protest and certain things you can't. You can't challenge a solicitation defect after award has been made. So we'll talk about some of the timing issues, because bid protests, just like, to harp on my analogy of the challenge flag in football, if you wait 5 plays and think about it and say, I don't like that decision a few minutes ago, too late. Same thing with bid protests. You have to act within the certain time frames. If you're going to challenge the ground rules for the competition, something's wrong with the solicitation itself, you have to do that before the deadline for that. You can't sit on that issue in your back pocket and then say, well, if I don't win, I'll raise that issue and get everything to start over. It doesn't work that way. You also can challenge if there's a competitive range established and you've been excluded. You can challenge that exclusion. That's earlier in the process. That award has not yet been made, but they're moving on without you and excluding you from the competition. The one that I think most people think of is the post-award protest, where you're challenging how you were evaluated or how the award decision was made, whether you were the better value than the person the company selected. You can challenge BPAs, blanket purchase agreements, that are issued under the GSA schedule. There are limits on task and delivery orders protests. So if you have a multiple award IDIQ contract, which all of the work is awarded under task orders or delivery orders, there are limits on whether you can protest that. They have to be above certain dollar thresholds to be protested, or if you're arguing that it's something outside the scope of that. So again, if there's a IDIQ contract for widgets and they issue a task order for some other product that's not under the contract, then you could say, wait a minute, I could have competed for that contract. I sell that type of product, but I don't have this contract because it's not in the scope. So there's a number of things you can protest, certain things you can't protest. Hopefully agencies have gotten better about this with the debriefing. I think there's been a mindset traditionally within some agencies that debriefing is just giving people fodder to file a protest, when really a well-informed debriefing. I've had several instances where the client's thinking that they were wronged in the evaluation, but then once they understand the rationale, they realize, yeah, we really don't have a good response to that, and we probably shouldn't protest. So. But every now and then the agency clams up, won't tell you much, and they want to protest, well, they should have given me more in the debriefing. That's not a protest ground. So again, I think that when they don't give you enough information, it almost forces you to protest, because it sounds like there's something that they're hiding. So hopefully agencies won't do that, but that's not a protest ground. Another big issue that is not protestable is whether the awardee is going to comply with contract requirements. So again, what GAO and what the courts will look at is, what are the requirements for the proposal? What are you going to be evaluated under? But you can't say, well, if the solicitation says you have to have X certificate to be acceptable, and they don't have X certificate, that's protestable. If the solicitation says that if whoever wins this contract is going to have to be able to deliver 20 widgets a month for the next 12 months, and you say these guys can't do that, that's not protestable, because now that's contract administration. They've signed on to a contract that says they got to do it. If they don't do it, that's a breach of contract that they can get into the disputes process with the government on, but that's not protestable. So I mentioned challenging issues with the solicitation. This slide goes through some of the issues that you can have with a solicitation defect. I think the broad principle is, if you see something that you don't think is right in the ground rules of the solicitation before you even know who wins the award, there's something that you think doesn't let you know enough information to do an intelligent proposal, there's some unfair advantage under the system, the evaluation scheme doesn't make sense. Those are all things that you have in your mind as issues with the solicitation before you even know whether you're going to win or not. And so those are the types of things that are solicitation defects that have to be protested before the closing date for receipt of proposals. And if you don't, then you can't raise it later. Then on the flip side, there's certain things that you don't know about when you're bidding. You don't think that you don't know how you're going to be evaluated when you're bidding. So if you find out how you've been evaluated and think the agency didn't follow the evaluation criteria, you think that they were unreasonable, they gave you a weakness for something that clearly exceeds the minimum requirements, that they did a bad best value determination, all of those things that where you thought that it was a fair solicitation as you understood it, but when you see how the agency applied those rules, you think they've made a mistake. Those are not solicitation defects. Those are essentially evaluation or award errors. So when can you file a protest? Again, these time limits are very important because if you miss these time limits, you can sometimes lose your opportunity, oftentimes lose your opportunity to protest. So as I've discussed, the solicitation defect challenges has to be filed before the receipt of initial proposals if it's in the original solicitation. What can also be tricky is maybe the original solicitation is fine, but the agency issues an amendment and that amendment has an error, something you don't like. In that case, you have the deadline is the next deadline for receipt of proposals after that amendment is issued. And sometimes those amendments only give you like a week to respond. So again, you have to be on your toes for these kinds of issues and make sure you protest them promptly, because if that window goes by, you'll be deemed to have waived that issue. For post-award protests in particular, GAO has a 10-day limit after you knew or should have known the basis of the protest, and we'll talk about how debriefings play into that in a little bit. But that's a hard and fast rule. If you miss that window, GAO says, see you later. The Court of Federal Claims is a bit more flexible, so if you're untimely at GAO, you can go to the Court of Federal Claims. But there's some advantages to going to GAO, including that if you file within certain time limits, there's an automatic stay of performance of the awarded contract at GAO. At the Court of Federal Claims, you got to file for an injunction, which is not automatic. So, you want to be within the time limits if you want to go to GAO. And again, that's sort of use the old cliche, you snooze, you lose. That's very true in the protest process. So as sort of a practical point, we always recommend if you are thinking that you might want to file a protest and but you aren't really sure, then engage with counsel immediately. Tell them that you're thinking about it. Maybe you haven't made a final call, but you don't want to sit there and think about it for 5 days, contact counsel, and all of a sudden it's the 9th day, the 10th day, and they can't put something together for you in time. So you really need to be attentive, and particularly on these things like where there's an error in an amendment that you only have 7 days to respond to. You can be on a very short leash to get something in. And now to get an automatic stay of performance, either you have to file within 10 days of the contract award, or if there's a required debriefing, within 5 days of the debriefing. So again, if you're in a situation where it's a negotiated procurement and you've requested a debriefing in a timely fashion and it's required to be given to you, that gives you a bit more runway. But then once you get that debriefing closes, now you got 5 days. So you got to, again, get that protest in within that window and make sure you do. So speaking of the topic of debriefing, so again, debriefings are required in a negotiated procurement. So if it's a FAR Part 15 negotiated procurement RFP situation, you've submitted proposals. These are the kinds of things where there can be discussions. Sometimes the agency will have rounds of discussions with you and ask for best and final offers. But those types of procurements, once you get a notice of award, as a best practice, you should immediately respond and say you want a post-award debriefing, because you have to request it within 3 days, 3 calendar days. So again, it's not 3 business days. So if they give you the notice of award on Friday afternoon, you can't wait till Tuesday or Wednesday to say, I want a debriefing. You have to respond by Monday. So that's why it should almost be like you set one of those out of office notices. If you get the notice of award, whether you win or lose, respond, thanks, I want a post-award debriefing. So you get that written request in within 3 calendar days, and then it becomes a required debriefing for those types of procurements. Now, again, I mentioned RFPs. Gets a bit complicated in the weeds. I'm not going to get into it in detail here, but I mentioned you can protest a GSA schedule, federal supply schedule by, and you can. But technically, most of those are done on RFQs or they're not competitive proposals. They're under more of a streamlined process where a full post-award debriefing is not required. They're required to give you a brief explanation of the basis of award or something like that. So because a debriefing may not be required, is not required for an RFQ as opposed to an RFP, you need to keep that in mind too, because you're not going to have these longer windows. We'll talk about how a timely requested debriefing can extend your windows to protest. If you're not in that scenario, you need to be attentive to whether if you're going to be able to get an automatic stay or not if you don't file within 10 days. So if it's a required debriefing, you've immediately responded, you want a written debriefing, and or responded in writing that you want a post-award debriefing, and they give you one, then you have 5 days after that debriefing closes to file a protest at GAO and get an automatic stay of performance. But you have 10 days after the debriefing to be timely. So you have up to 10 days after you knew or should have known of the basis of a protest, post-award protest, to file at GAO, and GAO thinks that window is extended to the closing date of a debriefing. So you have 10 days after a debriefing concludes to be able to file a protest based on the award and evaluation at GAO, and you'll be timely. But if you file it on day 6 or 7, you've missed that 5-day window for an automatic stay, so the agency can let the awardee continue to perform while you're challenging whether they should have been the awardee in the first place. So you really want to hit that 5-day window if you can. Another key point that I think clients sometimes don't always appreciate is these deadlines for debriefings are after the first date that a debriefing is offered to you. So again, sometimes the agency will say, hey, how about Tuesday for a debriefing? Tuesday's not good. That's my day off. I'm going to, or I'm going to be out of town or whatever. Can we do it, Friday? Agency will say, fine. But, the 10 days start counting on that Tuesday. So you should do whatever you can if the agency is offered a debriefing on a particular day to be able to. Now, if you can't, you can't. But again, keep in mind that it's the deadlines. These 10 days, 5-day clocks are from the date the debriefing was offered. Nowadays, a lot of the debriefings are just sort of emailed letters, and so you don't. Even if you're doing something else that day, they send it to you. That's fine. But anyhow, you just got to be careful if you're going to decline a debriefing. Another point that I think is important to keep in mind, this doesn't happen all that often, but again, we talked about procurements where there's a competitive range established. So the agency is doing competitive proposals. They get 10 proposals. They decide 4 or 5 are really worth pursuing. The other 6, they say, nope, you're no longer in the running. So if you get one of those notices, hey, you're not in the competitive range, we're moving on and evaluating and having discussions with these other people in the competitive range, but you're not part of it. The regulations give you the option to say you want a post-award debriefing. After you've gone ahead and made a decision, could be months from now, and made an award to somebody, give me a post-award debriefing. And some people think, oh, I'd rather do that, because if you look at the FAR regulations about what information they'll tell you in a pre-award debriefing versus a post-award debriefing, it sounds like you get more information in a post-award, because you do. They tell you, who the awardee is and, some of their overall ratings and their price, which they can't tell you pre-award because there's no awardee. Don't wait. Again, what you want to do, if you think you were improperly excluded from the competitive range, you want to get back in that competitive range before they move on without you. You're going to be really behind the 8 ball if the agency's gone several weeks or months into the future evaluating additional rounds of proposals, and you want to say, well, remember way back when you left me out? You shouldn't have done that. So always ask for a pre-award debriefing if they exclude you from the competitive range. Now, post-award debriefings. Talk a little bit about that. So there's now for Department of Defense procurements, they've adopted through the National Defense Authorization Act has had some provisions where they call for these enhanced post-award debriefings. So again, these are for DoD procurements, whether negotiated procurements, RFPs. There are, essentially it is a requirement now, and this is good. It's helped clarify. Oftentimes in the olden days, 3 or 4 years ago, there could be some uncertainty about whether, the debriefing had officially closed or not if you were able to ask some questions afterwards, ask follow-up questions. So now in a DoD negotiated procurement, you have a right in a debriefing. They should tell you that you have a right to submit written questions within a couple of days after the actual debriefing is given. And if you do, the debriefing doesn't close until the agency gives you written responses to those. So it's a good way, again, if you're thinking about filing a protest, you ask those questions to keep that window open and lets you work on your protest while you're getting ready while they're answering. Another aspect of the enhanced debriefings is that in certain large value procurements, you can get a redacted copy as part of your debriefing, a redacted version of the source selection decision document. And that's really helpful. Some agencies have done that previously already, but it's really helpful because there you get much more information than you typically would get about how they looked at the best value determination, how you were fully evaluated, your strengths and weaknesses. A lot of the stuff on the other offerors will be blacked out, it's redacted, but you get a much better insight into the award rationale than you might in just a bare bones debriefing. So those are things to keep in mind if you fit in the criteria described here to request or receive as a matter of right a redacted source selection decision document. And real quick before I move into the ways to win or lose protests, on the issue of written questions in the DoD debriefing, you have to submit those within that 2-day window for that debriefing to stay open. There was a case that was decided in the last couple of years where the DoD said, well, you have 2 days to submit written questions. The offeror did not submit written questions, but then tried to say, well, the debriefing stayed open for 2 days in case we submitted questions. And the court said, no. It was open for 2 days if you did submit questions, but if you didn't, it closed 2 days earlier, so they missed their window and they were untimely. And so again, you got to ask the questions, and you got to ask them within those 2 days. And then if it takes the agency 2 weeks to respond to you, that's on them. The clock is still stopped. But if you don't ask those questions, you don't get the benefit of that extra time. So I call these easy ways to lose a protest, and some of these seem common sense, but you'd be surprised how often this come up. So again, if you write a bad proposal, you're going to have a hard time challenging negative evaluation decisions that are based on that proposal. And of course, the issue is bad. What does that mean? Nobody thinks they're submitting a bad proposal when they submit it. At least I hope they don't. But again, you got to answer the questions that are asked. And the other thing that I think is oftentimes the curse of the incumbent is they have all the information in their head. They know what they're doing, and it can come out in 2 different ways that hurt them. They either know it but don't know how to write it. You get people who write a great essay on what they can do versus people who can do it. And so sometimes that can be a disadvantage. And they think, well, they know I can do the job. Again, sometimes these are essay writing contests, so you got to write a good essay. The other problem that sometimes particularly incumbents have is, well, the solicitation says, tell me about how to do X, Y, and Z, but that's not what we do. They know that we do W, Y, and Z. I'm going to tell them about W, Y, and Z because that's what really people do. That's what they need. Give them what the solicitation asks for. Don't rewrite the solicitation the way you think it should be. And so again, if you have a proposal that they can ding based on not following solicitation ground rules, you're going to have a really tough time winning. Another problem I think that people have in protests, and sometimes you can't help this at the initial protest stage, but they kind of go with what I call the kitchen sink approach. They argue about everything. Everything was wrong. And at some point, and this carries out in a lot of legal writing or other business writing, I'm sure, by the time you've gotten past 3 or 4 arguments, people start losing focus. And it's like, well, these guys complain about everything, so I don't really trust these 3 or 4 arguments that the first ones they made. So sometimes you got to argue a lot of different things to sort of get your foot in the door, get the agency report that the agency comes in with more of a record that you can then pick and choose. But the good protests, I think, start to figure out what are the winning grounds and what are the ones that are just not really worth pursuing and try to focus them. relying on conspiracy theories. Again, what I always tell clients is if you can attribute something to just, incompetence as opposed to malevolence or bias, go with incompetence, or just say they did something wrong, but you don't have to give a motive. They misevaluated me. They said that this was a weakness. You don't have to say it's because that they're out to get me. If you use the out to get me argument, then you're probably going to lose, because it's really hard to prove bias. Sometimes maybe there is an argument there, but again, if you can just show the agency made an error, you don't have to prove motive. You just got to prove that they didn't follow what they said they were going to do. Waiting too long to protest is an easy way to lose a protest. We've talked about that. If you miss some of these time limits, particularly at GAO, they will boot you, and they won't be at all sorry about doing it. Again, follow those rules. Another issue that you can get into trouble with is when you argue what GAO calls on a piecemeal basis. You make a couple of arguments that you knew of at the time, and then in a later round of briefing, like, oh well, there's also these other things, by the way, that were wrong. You got to make them all at the first argument, or they'll say, no, now you've more than 10 days late, you're late. So you got to raise any issue you think you should have been able to raise at the first instance. And then another issue is being vague or speculative. GAO will throw out a protest if you are just vague or speculative. An example of that is if you say, this guy couldn't have been better than me. There must be something wrong here. That GAO is like, you don't have a specific argument. You're just saying that you shouldn't have, there's no way you could have lost. That's not a protest. Where I think I've seen people overcome that speculative argument, because normally when you're filing a bid protest, you're not going to know much about the awardee's proposal. You presumably haven't seen it. But there are occasions where the solicitation says you have to have a commercial off-the-shelf product that does X, Y, and Z. And so if it's one of those types of procurements and the awardee, well, I know what commercial off-the-shelf products this person has, and his commercial off-the-shelf products don't do X, Y, and Z. Then you can come in very specifically and say, these guys should have been, I don't know exactly what they proposed, but I know what they can offer, and they don't have something that meets the solicitation requirements. That's specific. That's not speculative. That will get you through the door. Some additional ways to lose. If you focus on errors that don't make a difference, again, you have to have competitive prejudice. So if maybe the agency did screw up something, but that didn't move the needle, it wasn't important, that's not going to get you very far. This next one, and we'll talk about this a little bit more too, is agencies get a lot of discretion. GAO and the court, they're like, these are the agencies that are going to be buying the product or the service. And so if it's a technical issue, well, they should have recognized that my solution is superior. They're not going to second guess sort of subjective judgment calls by the agency for the most part. Where they will overrule them is if there's sort of some objective standard you can show. The solicitation said, you had to get 20 miles to a gallon. Mine offers 30 miles to a gallon in the mileage, so I should have gotten a benefit, not a weakness. Those are things that they'll look at. But if it's sort of like, well, they should have liked this type of design more than that type of design, that's very hard to get very much traction on. And then again, a lot of times in the post-award process, you want to pick at some aspect of the solicitation evaluation scheme or something else. Well, that was a really stupid way to do this. Well, you should have protested that ahead of time. And then again, another thing just to be aware of, you can file a protest at GAO without counsel. You can file it on your own. But if you do, and it's a post-award protest where you're going to be challenging how the evaluation was done, you're not going to get a complete record, because there's this thing called a protective order that allows outside counsel to see, your competitor's proposal without redaction, whereas you won't be able to see it. So you really are arguing with a hand tied behind your back if you don't have outside counsel that can, get admitted to the protective order and see the full picture. They may not be able to tell you the full picture, but you can get redacted filings after the fact, but you're not going to get a complete picture if you're dealing with a redacted record. Okay, so some 6 tips, try to cover in 5 minutes on protest success. Again, I mentioned this earlier, ask for legal advice if you think you need it early. It's better to be too early than too late. Again, there's nothing worse than getting a call from somebody who might have a valid protest ground and they've already kind of missed the boat. And again, on this whole issue about pre-award solicitation defects versus a post-award protest, I say the simplest way to look at it is if you think there's something wrong or unfair about the procurement before you've even submitted a proposal, that's a solicitation defect. I had a client, we filed protests about it's the lowest price technically accepted award methodology when there's some DoD provisions, regulations that say they really shouldn't use it for professional types of services. So, that was very important to this client because they wanted to they were afraid they would be underbid by somebody who was not as good. And under LPTA, they may lose. So they came in and filed a pre-award protest. Agency took corrective action. That got changed. So again, that was something that if they'd waited until after the fact and said, well, this never should have been LPTA, then they would have been out of line. Follow these solicitation instructions, read section L and M of the solicitation. Section L tells you what the proposal content and format needs to be. Section M tells you how they're going to evaluate it. That's not just there for the agency's health. That's what GAO is going to look at. That's what the court's going to look at and see, did they follow those rules? And did you follow those rules? If you had a really good proposal, but there's some required element that you're missing and they say that's a deficiency, you're unacceptable, boy, it is almost impossible to get GAO or anybody to cut you any slack. Hey, this was the instruction. You didn't follow instructions. You lose. So again, the other point here is if you are in a situation where there are discussions and they say, this is an issue we think is a weakness, address it. It sounds stupid, but if you don't address something that they raise as a weakness with you and it's still in your final proposal, then, that's going to be hard to overcome. You can file agency level protests. So there's 3 sort of areas to file protests with agency levels where you go back to the agency, the contracting officer themselves and say, I think you made a mistake, please fix this, GAO or the court. I would say that agency level protests when it's an award decision has been made generally are not advisable because at that point the contracting officer's already picked somebody and they're unlikely to second guess themselves on that. But with solicitation defect issues, they're usually more open to that. They may not have realized that they're making a mistake with something and they're a little bit more open. They haven't locked into anybody. So again, you can use those to your advantage. They're simpler than GAO. And particularly if you're under the gun, you protest deadline within a day or 2, you can crank out a letter that's a very simple agency protest and at least put your foot in the door on that issue. Mentioned this earlier on another slide, so won't dwell on it too much, but sort of getting back to the issue of focusing on objective versus subjective issues. The easiest way to win a protest is that, you can point to a specific objective requirement that you met, the agency said you didn't meet, it's black and white. If they're saying day is night, GAO will second guess them on that. If they're saying they prefer the evening to the morning because they're a night person, they're not going to second guess them on a subjective issue where the agency gets to make subjective judgment calls. So, things like, examples here where there's a price realism requirement in solicitation, the agency didn't do one. That's objective. They didn't do something they objectively said they were going to do. Those are things that you can have good success challenging if you have those facts. And then the last tip is, if you are the awardee, we focused a lot of this discussion on you protesting someone else's award. But it happens in reverse too. Sometimes you win and somebody else complains that they didn't get evaluated fairly. And so you have an opportunity in those circumstances to intervene to help the agency defend the award. And you really should, because when you don't intervene, you may think, agency's got my back. They're going to handle this. I don't need to spend legal fees or worry about this. The agency and your interests may not always be aligned. One of the easiest things the agency can do to make a protest go away is to take voluntary corrective action. So the agency may be inclined, particularly if you haven't intervened to show that you care about the award, they may be inclined to just sort of say, hey, we'll get rid of this protest. The other guy doesn't seem to care. We'll just we'll reevaluate and make another decision. So it really helps, I think, number one, to help stopgap if the agency's doing a bad job in defending the award, but also to make sure that they know that you care and that you're not just going to sit by if the agency decides to, get swayed by the protest and go the other way.
Good morning. I'm trying to do this to keep my time short as well. My name is Caitlin Trevelyan. I'm an associate attorney in Foley's DC office. I'm also in the Government Solutions Practice Group. I work predominantly with Aaron and Frank on some of these issues. Today, we're going through, so you've got a government contract. Now, what do? What are the requirements that you have to follow and comply with? And some of these are pretty simple. You might know them, but it might be a refresher here. You want to identify and understand key performance and compliance requirements. You also want to be able to identify periodic reporting requirements and develop and implement compliance and ethics programs in order to comply with those requirements. We will be mentioning, Aaron went through some of the penalties that you can face for non-compliance, everything from negative CPARS assessments to termination for default, to suspension and debarment. But ultimately what this starts with is reading your contract. And even prior to that, reading the solicitation, knowing the requirements in the solicitation, making sure that you can actually comply with those requirements. And ultimately, what is it going to cost you, the price in your proposal to comply with those requirements? So prior to submitting a proposal, a prime contractor must register in SAM, or the System for Award Management. When you register, you get a unique entity identifier and a commercial and government entity or CAGE code. There's no fee to register, and you can opt in or out of public searches. Obviously, some of the information is accessible via Freedom of Information Act requests, and some is not, including your accounting information. It's really critical for SAM representations and certifications that you make sure that that information is accurate and that you update it if there are any changes immediately. Unless otherwise stated in the solicitation, some of this information, like your accounting information, is what the government uses for you to be paid. So again, it's critical that these things are accurate, and it can also subject you to, if there are inaccuracies or misrepresentations, it can subject a contractor to, for example, penalties like Civil False Claims Act. Move on here. For all contracts over $6 million with a period of performance of 120 days or more, a code of business ethics and conduct is required within 30 days after the contract is awarded. The FAR does not specify what must be included in this code, but it does state generally that the code must make employees aware of the contractor's standards and procedures to facilitate timely discovery and reporting of improper conduct in connection with the government contract, and to ensure corrective measures are promptly instituted and carried out. The FAR does not require the code to be provided specifically to the government, and we'll go through the differences in the code versus an employee handbook in a second, but it must be provided to employees performing the work, obviously so that they can comply with it. But as a best practice, there should be training annually for both existing and new employees. So unlike an employee handbook, a code is typically made publicly available on the company's website, whereas an employee handbook is typically not disseminated publicly. An employee handbook also typically has a little bit more detail. The code covers at a very high level certain topics, and it really sets the tone from the organization from a top down. Here are some examples of the topics that should be covered in the code. We're going to go through at a very high level some of the more important ones. These are just examples. An employee handbook can have like a code of conduct that's included in it, and it could be sufficient to comply with the code requirement in the FAR. But Typically, if you have a one-pager kind of code of conduct in your employee handbook, that's not going to be sufficient. You're going to have something more in depth that cover the breadth of issues that the government wants to see and make sure that you're compliant on. Here's just a few more topics, some of which we'll go through, as I mentioned. Within 90 days after a contract award, the FAR also requires implementation of an ongoing ethics and awareness and compliance program and internal control system. Although there are small business concerns and commercial and product and service contractors that are exempt from these additional requirements, given the threat of penalties, including suspension and debarment, and for this and other violations, it is in every contractor's best interest to have some type of compliance program and to potentially flow that down or require your subs to do so, because as Aaron mentioned, if you have that obligation, it will help you if your subs are also compliant. And in terms of best practices in a business ethics awareness and compliance program, here are just some examples, including a written training plan, conducting training annually, again, not for just new employees, but for existing employees as well. Sorry. There we go. Tailoring training to specific roles, and this includes principals, and principals under the FAR is defined as not only officers, directors, partners, but anybody truly with supervisory or managerial experience or overseeing others. So you want to be able to tailor this training to those roles as well. Ultimately, the internal control system should facilitate timely discovery of improper conduct and ensure appropriate corrective measures are taken. The minimum requirements include, and here's a list, assigning responsibility at a sufficiently high level, conducting periodic audits, internal, external, and reviews of practices and procedures, as well as internal reporting mechanisms like a hotline for confidentiality and anonymous reporting so that you can get accurate reporting. If there is a violation, you want to know about it and be able to address it. Equal employment opportunity is a topic that should be included in the code. This federal contractors and subcontractors are required to provide equal opportunity employments. Essentially, you're not allowed to discriminate based on certain protected classes. The basic classes: race, color, national origin, sex, sexual orientation, gender, and for state and local contracts, that can be even more. And it requires government contractors to actually take affirmative action to ensure that equal opportunity is provided in all aspects of employment. This is not only from recruiting to promotions, to terminations, to transfers. It runs the gambit. This clause also requires the contractor to file an EEO-1 form, which basically provides the demographic breakdown of a contractor's workforce. And I'll go back real quick. So, and for the EEO-1 filing form, it's due within 30 days of the contract award, and annually. This year, it's typically due September 30th, but for this year, the 2022 data, it's due December 5th. The VETS 4212 report should also be filed if a contractor has a current federal government contract or subcontract worth $150,000 or more, regardless of the number of employees. This reports on the contractor's affirmative action efforts in employing veterans and should be filed again annually between August 1st and September 30th. If a contractor has 50 or more employees and at least one contract of $50,000 or more within 120 days of contract award, a contractor must develop an affirmative action program, or AAP. The contractor must also certify annually with the Office of Federal Contract Compliance programs, whether you are meeting your requirement for an affirmative action program. And here is the URL link for that reporting, again, on an annual basis. Contractors and their subs with qualifying contracts that contain a FAR E-Verify clause are required to enroll in E-Verify within 30 days of award, and also to initiate verification within 90 days of enrollment of all new employees working in the U.S. This verification must also occur for new employees within 3 business days, not calendar days, 3 business days of hire. And E-Verify basically compares the information from the I-9 forms to the government's records to confirm eligibility to work in the U.S. And because it's reliant upon the I-9 form information, it requires valid I-9s to be submitted. Federal law prohibits the use of federal funds to lobby any government official in connection with a federal contract. A company may employ services of a lobbyist to alert elected representatives of concerns that affect a company's business, but these must be disclosed, and the costs of employing such lobbyists cannot and have to be excluded from any invoice to the government. So you're not allowed to use federal funds essentially to lobby. And there are pre-award requirements for compliance as well as post-award. The disclosures, the form LLL disclosures must be made pre-award, as I mentioned, and any changes as well within 30 days of any change. Within 30 days of the end of the calendar quarter in which the lobbying occurred, the change must be disclosed. This also, lobbyists also have certification and disclosures for compliance as well. And these are for subcontracts, apply to subcontracts over $150,000. You must obtain certification and disclosures from your subcontractors as well. So the U.S. government has a absolute zero tolerance policy prohibiting trafficking in persons. And while typically we think of trafficking in persons as defined as, sex trafficking or things like that, the definition in the FAR is actually much broader. It not only includes sex trafficking, but it also includes other labor situations like indentured servitude or prison-like facilities or factories or other migrant agricultural worker situations. A compliance plan and awareness program is required for certain contracts that perform services or provide supplies outside of the U.S. and have a value over $550,000. Contractors must, in those cases, submit annual certifications regarding compliance plans and must obtain certifications from subcontractors for that compliance. Contractors must also provide immediate notice to the contractor if they become aware of any violation. And this is critical because a company can also be held liable for a single employee's violation of this or its failure to abate such violation. And penalties, again, can include everything from termination for default to suspension and debarment. The Anti-Kickback Act prohibits providing kickbacks, obviously, which is defined as anything really of value in exchange for favorable treatment. And while certain contractors and subcontractors are not required to establish the procedures under the FAR, they are still subject to the Anti-Kickback Act prohibitions in general. So this is a separate requirement, compliance requirement that's not only mandated by the FAR, but even outside the FAR. So it's best practice to implement these procedures in order to protect against any violations. Within 30 days of a contract award, contractors must publish a statement regarding a drug-free workplace prohibitions and provide all employees with a copy of that statement, and in addition, notifications that they have to abide by certain drug-free requirements for a contract, and establish an ongoing drug-free awareness program to inform employees. If an employee receives a conviction under any criminal drug statute and the violation occurred in the workplace, the employee must notify the employer within 5 days after the conviction. And in turn, the employer must notify the contracting officer within 10 days of receiving notice. And then within 30 days, the employer must also take action, whether that is taking action against the employee, termination, being one of the more drastic, or requiring a certain additional program, but must take action to address the issue within 30 days. Document retention. So the government can reserve the right under the FAR audit and records clauses to audit a contract up until 3 years after final payment. Sometimes retention periods can be longer in some cases. Typically, in terms of time guidelines, as you can see, for financial and cost accounting, pay administration records, and acquisition and supply records, the typical rule is 4 years, with some exceptions for 2 years. For U.S. government contracts and subcontracts at any tier, contractors have a duty to disclose up to 3 years after final payment if they become aware of any credible evidence, that's the term in the FAR, credible evidence of, one, a violation of criminal law. That can be fraud, conflicts of interest, bribes, gratuity violations, to violations of the False Claims Act, or significant overpayment to the government. The important thing to note for this clause is that it applies to all federal government contracts, prime contracts, subcontracts, regardless of the type, value, or duration. And this obligation also is independent of the FAR, so it's separate and apart as well. The government has an interest in who's performing the work and requires that for subcontracts exceeding $35,000, contractors obtain written representation from subcontractors as to whether the subcontract or its principals are debarred or suspended or proposed for debarment even. And if a contractor wants to subcontract with either a subcontractor who either it or its principals have been suspended or debarred previously, it must provide a compelling reason to the government for why it wants to do so. This clause is also required to flow down to lower tier contractors. So moving on to small businesses. So the use of small business concerns, or SBCs, by large contractors is required in some circumstances. The FAR requires large businesses awarded prime contracts and non-commercial item subcontracts in excess of $750,000 or double that for construction contracts to submit a small business subcontracting plan to the appropriate agency. The main thing to take away from this is that you can obtain contractors can obtain small business certifications from subcontractors. So basically, contractors can rely on such certifications from subs with respect to their size. A small business subcontracting plan essentially helps a contractor determine and meet its subcontracting goals because it has set aside goals or set aside dollar estimates for small businesses before beginning the work on a contract. There are essentially two types of plans, commercial and individual. You can see here some of the main requirements under a subcontracting plan in general. The difference in terms of an individual subcontracting plan, individual plan covers the entire contract period, including its option periods, and applies to a specific contract. And the goals are based on the offeror's planned subcontracting in support of that specific contract. Unlike a commercial plan, the goals are based on what you expect the subcontract expect to subcontract for the period of the entire contract, instead of, for a commercial plan, your past performance of the prior fiscal year. Small business subcontracting plans reports must be submitted to ersr.gov to the government. Individual plans should be filed semi-annually for the periods ending March 31st and September 30th. So they're due within 30 days of the ending of those periods. Summary subcontracting reports are due annually within 30 days of the ending period, September 30th. So it's important to note here that there are limitations in subcontracting that apply to certain types of contracts, including, for example, small business set-aside contracts, parts of multiple award contracts that have been set aside to SBCs, contracts that are sole source contracts to SBCs, and a number of others here. And we'll go through some of these limitations. So, for example, as part of the limitations on subcontracting, contractors must pay more than a certain percentage to subcontractors that are not similarly situated entities. And I'll define that in a minute under the FAR. But this clause recently changed to be more consistent with the SBA regulations. Previously, and I say recently, I think within the last couple of years, previously the limitation percentages were based on the cost of a contract, and now under the FAR, they are based on the amount of the contract. And the definition, as I mentioned, I define it here. So under the FAR, the definition of similarly situated entities also now includes first-tier subcontractors, which includes independent contractors that have the same small business program status as that which qualified the prime contractor for the award. So, for example, if you're a woman-owned business, it's a woman-owned business. And I'll go back real quick, and I didn't want to go through the individual percentages, but obviously here are the percentages that were based on, these are determinative based on the type of contract. You can see the 50% and 85 and 75. Oops, am I going the wrong way? All right, consent to subcontract is required for certain types of contracts, including cost reimbursement, time and materials, labor hour, fixed price, with unpriced contract actions. Consent to subcontract is also required if the contractor does not have an approved purchasing system. Consent may also be required by a higher tiered contractor. If consent is required, the contractor must provide the contracting officer notification in advance of placing any subcontract. All right, the FAR requires that a prime contractor must report the names and total compensation of its and its first-tier subcontractors' 5 most highly compensated executives if in the prior fiscal year, and it must include all of these, 80% or more of its annual gross revenue was from federal government contracts, subcontracts, and the like, and totaled $25 million or more in those contracts. And that info is not available publicly, whether it's through the SEC or IRS. Essentially, this clause is intended to apply to the largest contractors and subcontractors that have contracts over $30,000. And with respect to, so prime contractors under the same clause must submit additional information, not only for the prime contract involved, but also the first tier subcontractor, subcontract as well. The government will not pay for excessive pass-through charges. So, for example, pre-award, if a contractor intends to subcontract more than 70% of the work out, the contractor's proposal must identify the indirect costs and the profit margin that it's receiving and the value added by itself to the related work to be performed by that specific subcontractor. Essentially, you don't want a situation, or the government's trying to hedge against a situation where you bid something excessive and you buy out your subcontracts for a minuscule amount and you're not passing that along as well. This prime contractor's reporting requirement also applies to subcontractors whose subcontract more than 70% of the work to lower tier subcontractors. So again, it's something to be passed down. All right, so flow down. So as Aaron mentioned, in terms of flow downs, prime contractors must flow down the clauses that are required to be flowed down according to the terms of the flow down language in the clause. We've mentioned a couple of them here today, but these flow downs are often required in order for the prime to do their job and to meet its obligations, and it ultimately protects the prime or the upper level subcontractor from liability if there is a violation of those. All right, and overall, obviously the takeaways are, I can't stress it enough, to read the solicitation, read your contract, know what your requirements are. That's the document that provides you all of your rights, your duties, your obligations. It should not live in a drawer after it's signed. And then develop a code of conduct, develop procedures in place that can help you comply with these requirements, whether it be reporting requirements or internal control systems. Ultimately, to take the conservative route, if you have them in place to protect against these, hopefully that they're less likely to happen in terms of violations. And then, obviously that is because non-compliance and the stakes are so high in government contracting. If there is non-compliance or a violation, it could end in termination. I know I've mentioned it several times, but it could possibly end in termination for default or suspension and debarment.
So the Build America, Buy America Act, or BABA, as it's frequently abbreviated, is an element of the Infrastructure Investment and Jobs Act, the bipartisan infrastructure law. And I'm going to cover it at a fairly high level here. I'm going to warn you that there's too many slides to cover in the half hour that I have, so I'm going to go through them some of them very quickly. But they're here in your written materials as you want to maybe delve into them deeper. But what we'll talk about is what is BABA. What is that law? What does it mean? And then one key point to sort of stress at the beginning. I cover all kinds of Buy America rules in my practice, and this is always a constant area of confusion. The Buy American Act is for direct federal procurement. BABA and Buy America are for federal financial assistance. Don't get them confused because they're different rules. But that one little letter, Buy America versus Buy American, can make a big difference. One of the reasons we're talking about BABA here today is that the Office of Management and Budget, which is supposed to provide guidance to agencies to implement BABA in their financial assistance programs, issued some final guidance in August, or what they called final guidance. We'll talk a little bit about that. It's kind of interesting. It's not really final guidance, but it's the most final that we have right now. And give a few practice points for compliance, talk about waivers. But again, we'll cover some of this pretty quickly. So I've already kind of mentioned BABA comes from the bipartisan infrastructure law. It essentially For decades, there have been Buy America requirements in the Department of Transportation area in particular for, federal transit projects that receive federal funding, airport projects. And so what Congress decided was we want to have any federal financial assistance for infrastructure. And so that's a key concept. We'll talk about that in a minute. BABA applies to infrastructure projects. And so if there is an infrastructure project that is receiving federal financial assistance, there is now this requirement, baseline Buy America requirement, that any agency has to have. So, for example, Housing and Urban Development is an agency that did not have a Buy America requirement in its grants before. Now they're one of the agencies that's issued some guidance and some waivers on this. If they are, providing financial assistance to build a housing project, for example, there's now Buy America requirements on it. So again, this was meant to reach agencies that didn't have Buy America, agencies that already had some Buy America requirements. As long as they're consistent with BABA, they can continue to apply those. And so I think one misconception we'll get to is I think everybody sort of thought this was going to be a one-size-fits-all, standardized Buy America across all federal financial assistance programs. Answer is not that simple. There's different agencies can implement BABA in different ways. Some agencies are still applying their old, what I call their legacy Buy America requirements. So it's not exactly, it's very agency specific. And I think that's the challenge in the manufacturer space. You got to know what industry, what agency is funding the projects that you're bidding on. So there was some initial guidance issued in April of 2022. The BABA requirement officially went live in May of 2022. That interim guidance was sort of applicable and still applicable until I think next Monday, because the final guidance that was issued by OMB was in August, and it became effective 60 days for awards and things that are issued 60 days after that guidance. So now there's this final guidance that came out, and there's a new part of the CFR that has some provisions that embody that guidance. But again, this bullet about the implementation by individual federal agencies can differ is a key point, because we'll see that there's differences. So I'll go through this pretty quickly, but this is what I was mentioning about the difference between Buy American and Buy America. So direct federal procurement, if you the U.S. Army is building a new barracks on an Army base. That is a construction project, an infrastructure project that the Army, the federal government, is buying itself for its own use. And so that is subject to the Buy American Act. And that has its own set of rules that govern when the U.S. government is buying something for its own use, whether supplies, it covers supplies, but also construction. And since BABA is an infrastructure rule, we're sort of drawing a distinction with construction. So that is that one set of rules. And, we mentioned that if there's a new FBI headquarters that they're still trying to figure out where to build, that's going to be covered. Now, federal financial assistance, and I think there's a lot more awareness of this after the infrastructure law, because there's a lot of programs that it sort of funded that they're trying to sort of roll out now for EV chargers and for other, infrastructure projects, renovations. So that is money that is essentially issued to federal agencies like the Federal Highway Administration, EPA, other agencies, and then they basically distribute it out to state and local government entities to do the actual projects. So the end customer or the owner of the project per se is a state Department of Transportation, or it's a state or local, school district that's getting clean school buses, and it's not the federal government that's buying it itself. And so that's the difference. And so that latter category, where it's a state or local government entity typically who is doing the project that's getting some federal financial assistance. And again, it may not be 100%. It may be the federal government's kicking in $1 million for a $10 million project. But if there's federal funding attached to it, then BABA says no federal funds can be awarded to an infrastructure project unless everything in that infrastructure project complies with BABA. So again, that's another key indicator. If you're dealing with sort of a state or local government project, it's probably covered by BABA or Buy America, and it shouldn't be covered by the Buy American Act generally. So let's talk about BABA. Again, don't confuse it with the Buy American Act rules. I actually had a client forward me something where they said, well, this article says that the BABA percentage is increasing from 55% to 60 to something else. you didn't mention that to me. And I was like, well, I didn't mention it to you because that's wrong. That's the Buy American Act. And so here was somebody who'd written an article, wasn't a lawyer, somebody in the trade who was confusing Buy American Act contract clause with BABA. And, I said, you got to watch out for that. This is somebody who made this mistake. So again, got to keep that in mind. Here, this slide sort of recounts some of the mainly U.S. DOT agencies that had some Buy America requirements that predated BABA. By and large, they're still continuing to apply their pre-existing rules with a little bit of what I call a BABA supplement. One thing that these old DOT requirements tended to focus on was iron or steel. And there's this new category called construction materials, which is non-ferrous metals, glass, lumber, sort of a hodgepodge of things that weren't covered before. So under the old US DOT rules, there wasn't some special rule of origin for copper, a copper pipe or whatever. Now there is. And so they've kind of bootstrapped the construction materials rules under BABA to their existing rules, but they're still applying. So let's talk about the BABA requirement. So it applies to infrastructure projects that receive federal financial assistance. And this is a little bit of a simplification because there's some very fine details that are a little bit different, but I'm not going to get into for the purposes of general awareness. I think generally speaking, there's three categories of items that are subject to BABA requirements. There's steel or iron items, manufactured products, and construction materials. And so this requirement applies to items that are essentially incorporated into an infrastructure project as a fixture. There's this OMB guidance they made clear, if you're building a building and there's like desks and chairs and laptop computers and things that you're buying as part of the building, that's not covered by BABA because those aren't fixtures. Those can be moved. Same thing with construction equipment. You don't have to worry about BABA applying to the crane or the bulldozer because that's not being physically incorporated into the project. So those are some things to keep in mind. Infrastructure is defined very broadly. Again, essentially any kind of construction is probably going to be considered infrastructure. The exception would be that this last bullet they talk about indicia of infrastructure. There has been some federal funding to sort of, particularly in the semiconductor area, to sort of incentivize private companies to build factories. So, if it's a private facility that's receiving funding, and again, even in the HUD context, if they're providing private money for somebody to build a private home that's not an area of public accommodation or a public work, that would potentially not be covered. So that might be a distinction you run into. But in terms of most publicly owned, operated place of public accommodation, those are going to be considered infrastructure. Here's some links to the OMB final guidance, the original memorandum they issued in April of 2022, and then their final guidance in August 23rd, 2023. And as indicated here, it technically becomes effective next week. The OMB says they were planning to issue an updated version of their April 2022 memorandum that would become before next Monday, but they haven't done it yet that I'm aware of. So stay tuned on that. Why start a trend of meeting a deadline if now? So we'll see on that. So some of the highlights of the final guidance, things that we didn't have before that we were waiting on from OMB. They clarified and sort of slightly tweaked their definition of construction materials. And again, those are fairly specific, discrete, sole substance items, things that are essentially entirely glass. So for example, on the glass is subject to some specific definitions within the construction material that there's certain operations that have to be done domestically to meet the BABA requirement. But that applies if you're buying essentially a pane of glass. If you are buying a window that has a wood or plastic frame and glass has been, installed into it, that's going to be considered a manufactured product because it's no longer sort of a single wholly glass item. So again, the nuances with the construction materials are kind of interesting, but if you're, not in the market of selling things that are sort of those sole substances, I'm not going to spend as much time on construction materials because the rules are fairly complicated and they may not be relevant. They did also add some definitions of manufactured product and iron or steel products. that are important to sort of draw that distinction. And another area that's sort of been not entirely clear was how they're going to do the cost of components test. So we'll walk through these requirements real quickly. They also, OMB did clarify, and I think this is important, that you categorize your product into one of these three categories, and then that's the test that you apply. And so you may have if your product is a manufactured product, you may have iron or steel components, but you're typically not going to apply the iron or steel test of BABA to your iron or steel components. You're under the manufactured product test. You have to meet that test, which is, as we'll get to in a minute, that the manufactured product is manufactured in the U.S. and at least more than 55% of the cost of the components is of U.S. origin. The iron or steel test, we'll also get to this in a minute, is very strict in terms of tracing all the way back to the melt stage of the iron or steel, and every manufacturing process from the melting of the iron or steel through the final product has to be done in the U.S. So, you know, if you are subject to the iron or steel rule, you got to trace back to the melt stage of the iron or steel, but you don't have to do that for a manufactured product that maybe has an iron or steel component. You just have to know where that component was manufactured. You don't have to say, where's your foundry melt certificate? So that's kind of a key point. So the definition of iron or steel products, the definition is listed here, and essentially, you know, if it's wholly iron or steel, then obviously it's an iron or steel product. The question, I think the area that gets a little bit hinky is, you know, is it predominantly iron or steel? And so they finally defined predominantly, and it's similar to the test under the Buy American Act contract clause, and it's listed here, the cost of the iron or steel mill products used in manufacturing the product and a, quote, good faith estimate of the cost of iron or steel components. Now, again, I could talk about this for 15 minutes and I won't. I find that definition to be extremely confusing because, you know, we'll get to, for a manufactured product, there is a defined test to know what your cost of components are. So if the concept is the cost of an iron or steel component is considered iron or steel content, point blank, you shouldn't have to do a good faith estimate of it. So when I was go back, you know, when they say a good faith estimate of the cost of iron or steel components, you know, I think a better reading of that is sort of the cost of the iron or steel mill products that are used in the iron or steel components, which gets back to sort of the raw steel, maybe not the final added value of the final product. And if that's the test, and I think that, you know, should be, but it's not entirely clear from how they've laid this out here, then I think that's it gets more to things that we'd really consider iron or steel. I think nobody questions that a steel girder or steel reinforcing bar should be subject to this test. But if you think about like a commercial HVAC unit, there's a lot of iron or steel in there. And so if you're looking at the final value of the iron or steel at the component level, it's probably more than 50% iron or steel. But if you're looking at the sort of the raw foundry level steel in there as a percentage of the total cost of components, it may not be. And, you know, I'd be interested to know if there's any commercial, you know, HVAC vendors who are tracking the melt stage of all the iron or steel components. I really doubt it. So sort of discuss that, to me, that disconnect there in terms of what does the good faith estimate mean? But that's the definition. I've discussed already that the test is sort of going back to the melt stage, every manufacturing process from the melting all the way through the application of a coating. So again, people struggle with Buy America, but we're here in Michigan. Canada's across the way. If you have steel that's melted, shaped, formed, bent, whatever you want to do in Michigan, you send it over to Windsor to have somebody galvanize it. That's now foreign steel under Buy America. So again, everything has to be done domestically. Construction materials, this slide has sort of the 7 or 8 bullets of the different types of products that are in this category. Again, I'm not going to get into the details on it because it can get very granular. But essentially, if a product is wholly one of these products with quote unquote minor additions, and one example they've kind of used is engineered wood products. So if there's some glues or things that are in there to sort of keep the engineered wood together, that's not going to change it from an engineered wood construction material to some other product. But they didn't define what minor additions mean. So I think that's going to be potentially an area where we see variability from agency to agency because OMB hasn't said what that means, and they're kind of leaving it to individual agencies to fill in that gap. Again, if one of these specific construction materials, there are specific processes that are laid out in the definitions that this is what you have to do in the U.S., and I won't cover those. Manufactured products is probably the area where, most products fall into. And again, the definition here is that it's been processed into a specific shape or form or combined with other articles to create a new product with different properties than the individual articles, materials, or supplies that it's made out of. Essentially, it's, also if you're not predominantly iron or steel and you're combining multiple types of products together, multiple types of substances, it's going to be considered a manufactured product. And again, I've mentioned you have to, for that, product has to be manufactured in the U.S. and has to have more than 55% domestic content based on the cost of its components to be compliant with BABA. And this is a very key area where it's different from the Buy American Act, because right now, under the Buy American Act, there's actually the percentage is higher, it's 60% for the Buy American Act, but there's this exception for the cost of components test for a commercial off-the-shelf item. So if you manufacture a commercial off-the-shelf item and want to sell it to the federal government on a construction project for the new FBI headquarters building, and it's a commercial off-the-shelf item, if you manufacture it here in Detroit, then you've passed the test. You don't have to worry about where the components come from, what are domestic, what are foreign. It's a commercial off-the-shelf item. It's manufactured in the U.S. under the Buy American Act, selling directly to a federal government customer. That's all that matters. There's no cost of components test. There is no COTS exception to the cost of components test for BABA. So, if you're selling that to Michigan Department of Transportation's building some project, same thing you could sell to the federal government without an issue. If you're not at 55% domestic components, even if it's made in the U.S., manufactured in the U.S., it's not BABA compliant. So I think this is going to be an area with, I don't know if they're going to come out with a COTS exception. Nobody has so far. I don't think anybody wants to go that far. So there's going to be people who may have to adjust their supply chain to meet this requirement. Discuss here the definition of component. Essentially, it's an item one level below the end product, an article, material incorporated directly into a manufactured product. And so that's going to be very key. When you're doing the cost of components test, the first thing you got to do is figure out what your components are. Let me try to, you should classify a product into one of the three categories based on how it arrives at the job site. And so that's, but there's a little bit of leeway that OMB provided that if something is not fully assembled, needs some assembly on the job site, you can treat it as a kit. But don't go overboard, I think, is the key message there. People love to say, oh, well, the whole HVAC system for a building is a kit. It's a system. Let's treat that as the end product and all the different elements of it that show up separately or components. OMB said, don't try that. That's not going to fly. But by the same token, there's some things that just, you can't deliver to the project completely assembled because you got to assemble them in place. And I think what OMB is trying to recognize there is, in that kind of circumstance, you can still treat the elements of that item. If it's sold as a single product from a single manufacturer, you can treat that as a single product, even if it shows up not fully assembled. Okay, so I'm going to go through the waiver process very quickly. There's basically three grounds for waivers: non-availability, unreasonable price, and public interest. And they're pretty much standard rules across all the agencies, but different agencies have issued different waivers. And the key is, in this area right now, nobody wants to be seen as being lenient on Buy America rules. So there's a lot of pressure not to grant waivers, but sometimes they have to. Sometimes something is just not available here domestically. And so you have to sort of go through the process of trying to justify the waiver, and who really needs to ask for the waiver is the entity that's receiving the federal funding. So you may have a product that you think needs a waiver. You've kind of got to give the ammunition to the State Department of Transportation that's getting the funding so that they can go to their funding agency, FHWA, FTA, whoever they're dealing with, and say, we think we have a basis for a waiver. There are, if you go to the Made in America office website online, they've posted a number of links to different agencies' BABA implementation pages. And so different agencies have issued their own general public interest waivers. There were a number of sort of temporary 12-month, waivers so people can get used to BABA. Now there's some for de minimis, like up to 5% foreign or non-compliant content. There's some for small grants that are $250,000 or less or $500,000 or less. So there are some public interest waivers that apply across all projects. You got to check your agency. Again, that gets important. These are some of this slide here, 35, some of the common public interest waivers that a number of agencies have issued. But again, different agencies have slightly different standards, so check. I mean, there's some small grant waivers where they say if the grant is up to $250,000, BABA doesn't apply. Others where it's up to $500,000. And again, I think one of the challenges for people out in the world who have to deal with these is you don't have visibility on how much of the grant is. You're just seeing a solicitation document. So, but again, these are all things that are out there. I've mentioned that some of the Department of Transportation agencies had their own legacy Buy America requirements. I really don't have I've done multiple hour trainings on these rules, so I'm just going to buzz through this. Be aware of that there are these, if you're in the DOT space, that it's kind of going to be not necessarily what BABA says strictly. There's going to be sort of a gloss of their existing Buy America rules that may be slightly different. And there are some U.S. DOT public interest waivers that were issued just in August. 2 of them that will apply across all of those agencies, once new projects start rolling out with those. So let's try to get through the practical guidance in about 6 minutes here. So a headline on this slide is really important. And again, part of what you have to do if you're in a industry where you're selling products that are used in infrastructure are going to be subject to BABA, everybody wants me to give them the one-size-fits-all answer of how do I comply. You really have to know the agencies. You have to know the rules. There, for example, EV chargers. There's the Federal Highway Administration has rules for EV chargers in the NEVI program. EPA has some rules, which actually they've kind of made very consistent with the Federal Highway Administration, but EPA has its own program for EV chargers. So you got to make sure you know what EPA's rules are. So again, different agencies may have different interpretations, may have different waivers. You got to know which set apply and then track those and make sure that you're following those rules. I think you need to stay informed on the BABA waivers and guidance that different agencies issue. Some agencies are better about providing more specific guidance than others, but all of them tend to have websites where they post waivers that are under consideration, waivers that have been approved. And here's the link there to the Made in America office website where you can look at some of the links to the agencies to get their waivers. Again, one of the things probably, if you take anything away from today, read the solicitation, understand the bidding documents and what requirements apply. This is a constant issue I have with clients where they're lower tier. They're not a prime contractor bidding on a big, $15 million construction contract. They're coming in after the contract's been awarded, where somebody's, one of the higher tier contractors asking them to provide some supplies or be a subcontractor. And I got to say, you got to find out, look, what do the contract documents say? What does it say about Buy America? What agency is providing the funding? Because maybe you have one little piece that doesn't comply, but maybe there's a de minimis waiver, but I need to know what agency you're talking about. So again, you got to look at the bid documents and request them if you don't have them. And then another key point I think people need to be aware of is, this applies to the products that are brought to the job site for incorporation into the product, into the project, excuse me. So, you may sell an item that gets your upstream customer incorporates into their product that then gets delivered to the job site. So you're not providing something that directly goes into the project. It goes into somebody else's product. So you're supplying a component. So in that case, really all that's relevant is you don't have to do your own 55% cost of components test. They need to know where your component's manufactured. Your upstream customer who's making the end product has to figure out if they comply or not. But know where you are kind of in the food chain too. If you're at the component or subcomponent level, your requirements are going to be very different than if you're providing an item of supply that goes directly into a project. So again, and this is sort of a principle for all Buy America. If you only part-time play in this space, you need to make sure that the folks who are on your sales team doing your bidding and quoting are aware, have their antenna up for these Buy America or BABA requirements and are factoring them into their bids. If it has a BABA requirement, are you bidding something that complies? Are you being asked to certify compliance with your quote? If so, you better make sure you comply before you certify. Are you flowing down a requirement if you have a product that needs to beat the 55% cost of components test or needs to meet the steel or iron? Are you flowing down the requirements that would make sure you could document your own compliance? And that brings us to the slide about documenting your own compliance. So again, if you get audited, and that's sort of oftentimes what happens here is you do the project. Everybody right now wants to get all the money out for infrastructure, start digging and showing progress, making jobs. Everybody's happy. And then, 5 years from now, they want to go back and call the money back. And they start looking for ways to do that. And then it's, did somebody comply with BABA? So you need to know if you are providing a manufactured product, you're going to need to do that cost of components test. And that means finding out where your supply items you buy as components, where those are manufactured. It's not just good enough to know you're buying it from a supplier in Ohio. If that supplier from Ohio has a warehouse full of stuff that's been manufactured in China, that's not a U.S. manufactured good just because the supplier is based in Ohio. So again, documentation is important. And then there's a lot of gray areas in these rules, even though they've come out with multiple rounds of guidance. And, it's always better, I think, to be upfront about, well, I'm interpreting your definition of predominantly iron or steel this way, so I think I'm a manufactured product, and I'm certifying compliance based on the manufactured product test. If somebody comes back later and says, well, you should have been iron or steel, you've at least explained, you didn't have a blank certification, and they said, well, you certified all your iron or steel was melted and manufactured in the U.S. because you're an iron or steel product. It's like, no, I thought I was this other product. So again, if you have ambiguities or uncertainties, I think being transparent about what you're relying on, the basis on which you're complying or certifying compliance is important, because it gives you more of a defensible basis for saying, I, in good faith, relied on this. Maybe you think later I'm wrong. Okay, that may be a contract issue, but it's not a false claim or misrepresentation issue. And again, if you do have something that doesn't comply, you need a waiver. Better to ask for a waiver than not.
Hopefully. So recent updates. First, we're going to talk about TikTok. No, I'm not going to do a TikTok dance. I don't even have TikTok, for the record. I don't even know how to use it. But it's been a big topic of discussion now that the government has a FAR clause that implements certain prohibitions on the use of BitDance covered applications, which currently is only TikTok. The government's primary concern here is that unauthorized individuals can use TikTok to get access to your IT infrastructure. I mean, that's really the crux at what the concern is. Not because they don't want you looking at TikTok while you're at work. I mean, that's not it. And so there's clearly a security concern that the federal government has with respect to the use of TikTok, similar to the security concerns they have about certain telecommunications, video surveillance equipment, and other things that come from Chinese companies. So the problem with this clause, though, is we get a lot of questions about how do we comply? What does it require? And I find the clause to be internally inconsistent. And so it's difficult to then advise clients. And we've yet to get any clearer guidance. First of all, it applies to covered applications, which I said right now is TikTok. And then it applies to information technology, which is defined as IT, equipment, interconnected systems, so on and so forth. If the equipment is used by the executive agency directly, so that's the easy part, right? The federal government comes and uses your system or uses your software that comes on your system. That's an easier thing. Or is used by a contractor under a contract with the executive agency that requires the use of that equipment or of that equipment to a significant extent in the performance of a service or furnishing of a product. Well, what contract really requires your use of a specific set of equipment? I think that's especially IT equipment. Now, you need to use your email to correspond with the government. Does that mean that your computer's a required piece of equipment? The contract doesn't say that you have to use that computer or use your computer, but clearly it's something you need to do. So it's a little vague, and it could be very narrow in that the contract doesn't specifically say I need to use this information technology, and therefore I don't have to comply. The problem with that is that the definition says it includes computers, ancillary equipment, but it does not include any equipment acquired by a federal contractor incidental to a federal contract. Well, I would say all the computers you use are incidental to your federal contract, right? Because you rarely buy a computer just to perform a contract. You use your computers in the ordinary course of business to do all of your work, including your government contract work. So then that leads me to the initial conclusion, you know what, I don't think it really means all computers that you have. It doesn't mean your cell phones. Well, then they go on to say, the contractor is prohibited from having or using a covered application, TikTok, on any information technology, again, including computers, owned or managed by the government. Okay, can't have it on a government piece of equipment, we get that. Or on any information technology used or provided by the contractor under the contract, including equipment provided by the contractor's employees. Now, a lot of companies have bring your own device programs, right? And that to me is what they're referring to. But how often do you have a government contract that specifies the use of equipment that is a employee device, a bring your own device from an employee? It's inconsistent to me. So I don't know why you would bring in that it includes equipment provided by a company's employees, like their cell phone, like their iPad, like their laptop, but then have it say, well, it doesn't apply to incidental equipment. When is a bring your own device not incidental to a government contract? So I struggle with this but here's what I tell clients. And again, this flows down to all subcontracts, including subcontracts for commercial products and services. It's applying to all of your new contracts. What are the practical considerations? My advice is clearly the federal government is concerned. They're concerned that the use of TikTok on your information technology systems can be a backdoor for bad stuff and for bad actors to access your system. If the government is that concerned, shouldn't you similarly be that concerned? In addition, how critical is access to TikTok for doing your business? I would say, if anything, it's probably a big distraction for a lot of employees. But again, I might be biased. I'm not a TikToker. So then the question is, well, I think the easy thing to say is you can't access it on our computers. You know, there's a lot of websites that are banned for other reasons. Ban that website. I think that's the easy fix. Then the question comes down to, well, what about people's cell phones, right? Everyone uses their cell phone, a lot of them for work. You get your work email. A lot of people have certain firewalls, right? Maybe it's a very segregated system where if they access your email, other stuff is blocked off. That might be a basis to say, okay, you know, maybe even if they have the TikTok app on their cell phone or they access it through the browser, no one can get in. We're very confident about our firewalls. That might be, and you might be able to take that approach. However, again, I don't want to have the client in the situation of saying we took that approach and someone used TikTok to access our system and take us down, right? And so I kind of come back to how critical is it for people to be able to access TikTok on their phones? Can't they just use it on their personal computer or a personal device or a personal iPad that's not connected to work? I mean, is it that critical to everyone's life? Maybe it is. So it really comes down to your culture and your company and how risk averse you are. Because I will tell you, I think this is very ambiguous. And you could take the wholesale approach. You can't access TikTok on our work computers, on your cell phone, anything that accesses our IT system. Clearly, if someone is one of your employees and they access TikTok on a system that doesn't connect to your network, you don't care. This isn't about the fact that the government's concerned about the content on TikTok. They're concerned about you accessing it from IT systems that also contain government information, such that people could get access to that government information, exfiltrate it, or impact your ability to perform on your government contracts. Flow this down to lower tier subcontractors. That's important. In terms of policies, there's nothing in the clause that requires you to do internal audits. It doesn't require you to necessarily have something that goes into people's cell phones, and if they have TikTok, you go in and delete it for them. I mean, it doesn't go that far. But I think having a reasonable policy, either prohibiting use of it, discouraging the use of it, again, have your IT folks do their own research and their risk level of concern about use of TikTok on your IT systems. Okay, next topic. I've got a lot of questions about types of information. There's a lot of terminology thrown out there, a lot of acronyms: federal contract information, controlled unclassified information, covered defense information, and classified information. So I thought it would be useful to kind of set the record here. What are these different types of information? How are they used? And why does it matter? So the first is the basic FAR clause. So this would be in all government contracts. The other requirements that we're going to talk about are DoD specific. So if you don't have any DoD contracts, this is the main clause you're going to see, although other agencies may also have some sort of cybersecurity protections. So the first set of information that the government wants to protect is federal contract information. This is information that's not intended for public release, either provided by the government or generated by the contractor for the government. This is going to debunk the first myth. Contractors can generate CUI, CDI, FCI, classified information. Everything we're going to talk about today is not just about what the government or your customer gives you. It's also something that you can generate, and that's important to know. It's under a contract to develop or deliver a product or service to the government, so it has to do with information that you are developing or receiving relating to your performance of a government contract. It does not include information available to the public, so nothing on publicly available websites, and not simple transaction information that's necessary to process payments. So I'm sure you guys have all gone to USAspending.gov, the Federal Procurement Data System. Any information that's up there is not FCI, it's publicly available information. So some folks are concerned that information about their prime contract number, the awarding agency, the value of the contract, oh my gosh, this is sensitive information. It's probably on FPDS and USAspending.gov unless it's classified, therefore it's not FCI. That is publicly available information. There's also no marking requirement on the government to identify something as FCI, which again makes it a little more challenging for you to protect it. But these FCI is only subject to these far basic safeguarding controls, which probably the majority of IT systems have in place. And if not, they should, as good housekeeping practices. CMMC is the upcoming wave of cybersecurity requirement compliance, which I think by the end of this month, we're supposed to maybe have a new rule on it. It's coming up soon. Anyone who only has FCI, you're at the CMMC level 1 under CMMC 2.0. And we'll talk a little bit more about CMMC. The next category is controlled unclassified information, and this is the biggest buzzword in government contracts, CUI. This is unclassified information. We'll talk separately about classified information. It's defined in the Code of Federal Regulation, and it's the information the government creates or possesses, or again, an information a company creates or possesses for or on behalf of the government. You can create it as part of your performance of a contract. And that there's a law, regulation, or government-wide policy that either requires or permits the agency to put some sort of safeguarding or dissemination controls on it. It does not include classified information. And there's a CUI registry, and there's a link here, that identifies over 100 categories of CUI. Keep in mind, though, again, this is only CUI that you are creating or possessing for or on behalf of the government under your government contract. So one of the categories of CUI is personally identifiable information. And so a lot of times clients are saying, wait a second, everything HR has is now CUI. It's not, because your HR information is not developed related to a government contract. It's not provided related to a government contract. However, if you have a contract to get information related to government employees, DoD employees, and you have all their health records and you have all their PII in there and your record management system for the government in that regard, yes, then that is CUI because you have that personally identifiable information as part of your performance of the government contract. If you have any CUI in your information technology system, any of your systems, you will need to comply with level 2 under CMMC 2.0. The key difference, too, between FCI and CUI is that there's a marking requirement for CUI. The government and higher tier contractors, as well as you, when you develop CUI for the government, should have a CUI marking on it in order for it to be considered CUI. There's specific language that needs to be included. There's this legend here I have on the slide that you're supposed to see that's supposed to include the reason, the CUI category. One of my biggest pet peeves, though, is the government has gotten a little CUI happy in marking everything as CUI. And I was mentioning to someone else earlier that one of the frustrations is that the government comes and audits you and they issue an audit report. They mark the audit report as CUI. The only reason it's marked as CUI because it's your company's private information in there. But now you're in a position of, oh no, we need to protect this in our system. We have to segregate it. Only certain people maybe can access, all of these restrictions. We can't just email it to our accountants. We can't email it to our lawyers. We have to transmit it through these secure means. But it's really your information. It's only CUI vis-a-vis the government, but the government has yet to distinguish between CUI that's for your protection and CUI because it's within the government. So that causes all sorts of problems. The next category is covered defense information. Covered defense information is the current term used in the DFAR. So this only applies to Department of Defense prime contracts and subcontracts. It includes CUI. So CUI is a category of CDI. It also includes controlled technical information, which is any information that is subject with a military or space application that is subject to controls on its access, use, reproduction, modification, performance, display, release, so on and so forth. So that would be export controlled information under ITAR or EAR 600 series. And it also specifically includes any information marked with a distribution statement B through F. And this is where companies need to pay attention to, am I creating CDI or CUI? If you have a CDRL, your contract data requirements list, that says for these deliverables, you need to include distribution statement B, guess what? You're creating CDI and your deliverable is CDI. So then the question comes down to, well, you know, we have this secure portal in which we transmit CDI, but our engineering system doesn't comply with all the NIST standards. But that's the drawing that you're ending up delivering to the government that's being marked with distribution statement B. So there's definitely a little bit of a gray line at what point does what you're pulling together for that deliverable become subject to that distribution statement such that you need to protect it internally, and which of your systems need to comply. It's not always enough just for the system that transmits information or receives information from the government to comply, or wherever you store it to comply. You have to think about your systems where you're creating that information as well. And that's the tough one. CDI also needs to be marked or otherwise identified in the contract, task order, delivery order. And so it's supposed to be identified in the contract as, we're going to be giving you the CDI, you're going to be developing the CDI. Again, the distribution statement's the easiest way, I think, to identify our deliverables going to be CDI. The government has not been very good about, okay, these are the things we're going to deliver you that's going to be qualified as CDI. They don't do that in their contracts, despite the fact that they should. So under CMMC, DoD uses the term CUI or DoD CUI instead of CDI. I don't know why they've changed their acronym on us, but it's really kind of all in the same. So we use those terms somewhat interchangeably at this point, although the proper term is CDI currently under the DFAR. And then you have classified information. And a lot of times I ask companies, oh, what about CUI, CDI? Oh, nothing secret, top secret, classified. Well, wait a second, that's something completely different. Controlled unclassified information is one thing. Classified information, you should know if you have it, because you need a facility security clearance as a company in order to, number one, have it at your facility. You need certain safeguards in place in order to have it on any IT system, in particular, heightened standards. And so you would know, but this is information that's secret, top secret. There's a very small subset of contractors out here who have access to this type of information. But I'd be remiss if I did not mention it. It's a completely separate category, and it's outside the realm of the cybersecurity requirements in CMMC. It's outside the realm of CUI. It's its own separate set of regulations in the NISPOM, which is now codified at 32 CFR Part 117. So what are the key takeaways to understand categories of information? Again, what Caitlin said, read your contract, your solicitation, your purchase orders. When are you going to either have access to CDI or CUI? When are you going to develop it and deliver it to the government? You want to make sure that you're closely looking at anything you receive from the government or a customer. Just because it's marked CUI doesn't mean they realized it or sent it through the proper channels. So before you just hit send or forward on a document, make sure you open it up and see its marking. In particular, as I said, the government may have marked it for your benefit, but it doesn't change the fact that it's marked as CUI, and within your IT system, you need to protect it accordingly. So really make sure before you hit send, even if you think you know what the attachment says, you read it carefully. I've been seeing some higher tier contractors including these markings on solicitations or RFQs or other documents where maybe you wouldn't expect to see it, but it's on there. If you receive a document from the government that you think probably contains, or a higher tier contractor, you think it contains CUI or CDI, but it doesn't have the right markings on it, why don't you ask them before you disseminate it? the last thing you want to do is use the argument, well, clearly was export controlled, but it didn't mention CUI or CDI, so I sent it to my counterparts in China. You don't want to do that. So if you're not sure, if it's not properly marked, definitely ask the question. On the flip side, if you think that something is, someone got marking happy and it's marked CUI and it shouldn't be, then feel free to ask them, hey, can I share this? Can I disseminate it? I'll give you another example. Anytime you make a mandatory disclosure to the DoD OIG, they go ahead and mark the confirmatory notice as CUI and they tell you not to distribute it to anyone. And I'm like, well, clearly I need to send this on to my client, government. So I often will say, okay, government, can you confirm I can send this on to my client? Otherwise you're really tying. And oh yeah, go ahead and do that. But I just like to get that extra confirmation so they don't see me as violating their utmost restrictions on there. So comply with the government markings. If you reproduce anything that has the markings, make sure the reproductions also have the markings on it. If something has to be delivered with a distribution statement, make sure the distribution statement is properly on those deliverables. We have seen a recent uptick in cases under the Civil False Claims Act for failing to comply with these requirements. This is an area that's ripe for whistleblower claims, especially for those folks in the IT department who might be concerned about whether or not you guys are following all of the requirements that you should be. And so it's something to make sure that you're diligent about. You definitely don't want to have a situation where you have a breach and you have to go to the government and say, well, we just kind of didn't really comply with these requirements. We didn't think they were important. And a failure to comply with the requirements was the reason why the breach occurred. So in terms of the current cybersecurity requirements, those are in the for Department of Defense contractors. Those are in the DFAR, and there's 5 main requirements. Number 1 is to provide adequate security. Number 2 is to rapidly report cyber incidents. Rapid reports are 72 hours of the cyber incident that impacts a covered contractor information system, which is an information that stores, receives, processes CDI. You need to submit malicious software that's discovered and isolated to the government, preserve and submit media, and importantly, flow down the clause. The only contracts that do not have this clause in it are those that are for COTS items. So commercially available off the shelf prime contracts do not include this clause, subcontracts do not include the clause, but otherwise it's a required flow down. The flow down says it's for contracts for operationally critical support or for which subcontract performance will involve CDI. Sometimes you don't know at the outset if it will or not, so oftentimes you see it flowed down. Right now, what the DFAR clause requires in terms of cybersecurity compliance is for companies to implement the 110 security controls in NIST SP 800-171 in any information system that processes, stores, or transmits CDI. You can assess compliance either doing a self-assessment, you can get a third-party assessment. There's a ton of vendors out there who can come in, assess your system, give you a traffic light, red, yellow, green, here's what you need to do, here's your roadmap to compliance. You should have a documented system security plan as well as a plan of action and milestones. Under the current DFAR clause, you do not need to be 100% compliant with all 110 metrics. The government has allowed companies to implement this over time, self-comply, self-monitor. And the reason why CMMC is coming about is government contractors are not doing it. They're not doing a good job of it. And the government's getting frustrated and saying, okay, we're going to have to come in and be a little more stringent on this. Currently, contractors also have to self-attest to their compliance. And this is in a solicitation clause as well as a contract clause, which says within the last 3 years, you have had to do a self-assessment of all your covered contractor information systems of your compliance with the NIST SP 800-171. The interesting thing about this is the government doesn't tell you what a passing score is. There's no minimum score requirements. I've never heard the government coming back and saying, you reported a score of 5, you're out of here. We're not going to award to you. It's very unclear what the government's doing with the information. The other awkwardness is that it's required to be flowed down to your subcontractors. So they need to tell you if they've done their self-assessment, but you don't get access to their system, the government system, to know what their score is. So they could tell you we did our self-assessment, we got a 5, and you go ahead and give them the subcontract, the government comes back, well, why would you give it to them? They had a 5. Well, we don't know. So it's interesting the government's requiring the self-assessment, but it's unclear what they're doing with the information. So cybersecurity maturity model certification, CMMC, is where the government is headed. They initially put out a 1.0, then they came out with a version 2.0. It expands on the current DFAR cybersecurity model. And then for some contractors, though, there's going to be a requirement for third-party certifications, no more self-certifications. Like I said, I'm hoping by the end of the month we'll get more requirements. There are the three levels. Level 1 was that federal contract information FCI level, and there's 15 requirements in that with an annual self-assessment and an annual affirmation. For level 2, which is where most contractors will fall, pretty much any of those currently subject to the DFAR clause, 7012 clause, 110 requirements that align with the current NIST SP 800-171. There's going to be a triennial third-party assessment for priority acquisitions or a self-assessment for non-prioritized acquisitions. Here's the problem, though. The government decides what's a prioritized or non-prioritized acquisition. You're not going to know until that solicitation comes out. You have a month to submit your proposal. Who wants to all of a sudden try to get that third-party certification within that month? Otherwise, you might not be able to bid. So there's that situation as well, where it might really tend to have most companies going for that third-party certification so that they are eligible for prioritized acquisitions. But we'll wait and see what the final rules look like. And then level 3 also has an additional requirements of NIST SP 800-172, and this requires a triannual government-led assessment as well as annual affirmations. So moving on for cybersecurity, the last topic I'm going to talk about today is technical data markings. This is a big issue for contractors who are concerned about marking data when it's delivered to the government and maybe also then given to third-party contractors, because you want to make sure that those contractors are on notice of what the restrictions are vis-a-vis them. But the government is strict in terms of what can and cannot be on data delivered to the government. Some companies have 2 sets of data. This is the marking on the data that goes to the government. This is the marking on any data that goes to third-party contractors. It's just burdensome and cumbersome. So under the DFAR clause relating to non-commercial product or service technical data, if you deliver any technical data without a marking, it's considered delivered to the government with unlimited rights. If you are asserting something other than unlimited rights, SBIR rights, limited rights, government purpose rights, you need to include a specific legend on that technical data that is exactly what is identified in the DFAR. You cannot deviate from it. If the government doesn't think that you marked something properly, they can challenge it, and it's up to you to justify the restrictions. Yes, this is limited rights data because we developed it at private expense. Yes, this is government purpose data, so on and so forth. For technical data that pertains to a commercial product, there's actually no legend required. So that's the one place where you have some leeway, is that if it's commercial product technical data, you can use your standard commercial marking, and that's permitted by the DFAR. Here's what the DFAR says about the marking requirements. It says only the following legends are authorized under the contract: the government purpose rights legend, limited rights, special license rights, and or a notice of copyright. There was a recent Boeing case in the Federal Circuit, recent 2020. So Boeing included on documents delivered with unlimited rights. Again, under the current clause, there should be no marking on anything delivered with unlimited rights. They included a legend that said non-U.S. government notice, Boeing proprietary third-party disclosure requires a written approval. I think they had some other variations of that. They had a copyright legend, and the government said, no, you can't include any legend. It's delivered with unlimited rights. The Armed Service Board of Contract Appeals agreed with the government that you can only include in those deliverables a legend specified by the DFAR. The Federal Circuit disagreed. They said that the DFAR is silent as with respect to legends a contractor can include on technical data that is meant to restrict third parties other than the government. It doesn't address that. It just says that vis-a-vis the government, these are the markings. It doesn't say if you can include any restrictive markings that restrict third parties. And because of that, they said that it's okay under the DFAR clause currently to include such restrictive markings with respect to third parties. However, they remanded a case to the ASPCA to address whether Boeing's proprietary legend restricted the government's rights, because I think the government was arguing, well, this still contained a restriction on us as well. The parties ended up settling the matter, and attached to the settlement dismissal notice at the board, there was a copy of the settlement agreement where there was an acceptable legend that the parties had agreed upon. But what's interesting is on December 19th of 2022, the DOD issued a proposed rule that specifically stated in the proposed rule it's in response to this case. So the DOD is proposing, it's a proposed rule, it's not yet binding, so you don't yet need to comply. We'll see if it gets altered, but there usually is, a comment period, and then interim or final rule gets issued. But in the proposal, DOD wants to amend the DFAR to limit restrictive markings on non-commercial technical data and computer software to only those in the DFAR. And they are adding a legend for unlimited rights data. And they're going to expressly prohibit restrictive markings that are directed to non-government third parties. They said the Federal Circuit said we were silent about it. We're no longer going to be silent about it. We're going to be express about it. They're going to continue to permit contractors to use their own legend on commercial technical data, but any restrictive marking used must accurately reflect any government license rights that they have in the data. So this is the proposed unlimited rights legend. This is going to impose a pretty big obligation on contractors who have a lot of unlimited rights data to then go back and add legends where maybe you said, okay, well, it's unlimited rights. We don't need to do anything. Now you specifically need to add a legend. Again, to the extent the rule goes through. So what are the key takeaways? Currently, until that rule's in effect, based on the Boeing case, you guys can go ahead and include a legend that restricts third-party access to information, and then the proper government restrictive legend, provided you are clearly distinguishing between what is for the government and what is for third parties. Any data has to be conspicuously and legibly marked with the appropriate legend, so it can't be so tiny that no one can see it. You can identify technical data restrictions down to the lowest identifiable segregable level. So if you have a report and part of it is limited rights, parts unlimited rights, parts government purpose rights, make sure you have some sort of color coding or some way for the government to identify what parts of the report are subject to which restrictions. And so, like I said, until the government takes action otherwise, that Federal Circuit decision stands, and you can go ahead and include those markings on data delivered to the government. That is it. Can you bring